Hi, y'all. It's Chris with Bama Law, and we're back again. We're going to do part two on how to be or how to have decorum in the courtroom when you do opening and closings, unlike that utter, I don't even, oh my God, I don't even know what to call him. Moron prosecutor, Lewen. I've never seen anything like, I've never seen somebody object hundreds of times in a trial. It may be it may be a record. That's possible. It could be a record. It might be. So I brought up some stiff on here so we can go through it. I'm not going to do any videos or anything like that today. We're just going to try to take it easy and kind of go on a one-way law class, but that's kind of like a one-way Socratic method, and it doesn't really work. But anyway, hopefully you'll stick along. All right, cool. All right, definition. I wanted to start off. I left off with this in the last one. It's kind of important. In any trial. It's a big deal. You don't always have them, but sometimes uh, sometimes it's not a problem. You kind of trust the other side, and um, you each know what's coming and what shouldn't, and you don't need it. But they're called motions and limine. Um, and I think they even had it in that trial. I mean, you'll hear it in every trial at least once. Usually, it's a motion and then the word in, like into, in and then it's limine, Limine. Okay. Go up here. Make this bigger for you. I don't know. Can y'all see that well? Yeah. Try a little larger. I don't want to make it too big. I'm blind, but damn, I ain't that blind. Um, yeah. Oh, why is it doing that? See, now it's got this crap over here. I want it the whole background. Let me see if I can't get this fixed. Mm, well, uh, sorry, guys. We're just going to have to work with it. I don't know. I'm not a professional. I'm just a screw up lawyer. So there you go. Let me get this out first. I am a licensed attorney in the state of Alabama. I have been for well over a decade, and I don't have a full caseload. I'm not in retirement. It's kind of complicated, but I'm doing this on the side for fun. I do a lot of general counsel type work temporarily until I had to go back, and go back into private practice and do what's called hanging your shingle. It's rough. It's hard work. People don't come to you. You got to find them. So that's what I'm doing. So at the very beginning of the Alabama bar, and I've been meaning to do this on like all 100 videos. Alabama bar requires me to tell you that I am not your attorney, and I'm gonna say I am not your damn attorney. Do not take this as legal advice. It damn well ain't legal advice. Take it serious that if you need help, get someone. I know it's a con artist market at this point where lawyers charging $400 damn dollars an hour, which is an absurdity because you got to go to their office. You go to an office and say how beautiful, oh, it's wonderful, it's plants and all these books. Lawyers don't need thousands of books in a library. Half of them are cardboard cutouts. They just look like books. If you go upstairs to the library and start poking through them, they're fake. Yes, look it up. You can buy them. I'd sadly, yes, I know lawyers that have done it in big firms, actual big Birmingham firms that have done it. It's a joke. It's a joke because you have Westlaw and LexisNexis, and you have internet, and you have, you've got artificial intelligence. It'll pull cases. You just got to make sure, just like with any case, that it's on point. Um, anyway, I am not your attorney. I'm not giving legal advice. This is just for entertainment purposes and a little bit of legal knowledge, and hopefully to get you to not go to law school. We got enough lawyers for the next 30, 50 years. Let us die off. Give it another 30, 35 years. Maybe your grandkids or something could be a lawyer. And, then if we restrict it enough, you'll have a good amount of demand for not enough people. Calling medicine today, but yeah, medicine's getting destroyed too. So, all right, so let's get in with it. Let's get in with it. All right, yeah, if I can get it to work. Story of my life. All right. No, stop. I don't want co-pilot. I don't like being co-piloted. Co-piloting sucks. All right. Can I get this on one page? Yes, I did. All right. Definition. We're going to definition. This is the only thing I don't like about this little Google Docs. I can't get it to highlight like I want. It's one time and then it cuts off. It's not like through Microsoft Edge where you can just keep using it, which is neat. Which is probably what I should be doing. So the definition: motion in limine is a pretrial motion filed by a party to exclude or admit specific evidence before trial begins. The point or the goal. See, there it went again. Did not do what I asked it to. I say that's stupid. I should just be able to keep going. The goal is to prevent prejudicial, irrelevant, or inadmissible evidence from being introduced in front of a jury. That is your whole goal. It's Latin for literally what it means. Motion to limit, but it can also to allow. It works both ways. It's usually meant in the limiting factor, though. We want to keep. I don't know. A witness has not expert, has let's say they just witnessed a murder, a horrific murder, and it's horrible, and they saw it, and they are a physician. They didn't, try to save the body, the corpse, or the person. They just saw it. Okay, they just saw it. You would want to try to limit anything they say on the stand. You don't want them to be a medical doctor. They can't. They either need to testify as an expert witness, or they need to testify that they saw somebody die. That's it. So a motion in limine in its basic form, that'll get you that. Okay, so that way everybody knows going in the front door. Hey, I can't talk to this guy and elicit questions about whether or not he thought he was died at that time, or he had died a horrible death. Or no, can't. So those are what those are for. I've had even stupid prosecutors do things like motion in limine on me, which got denied, but it was on me, that I could not use my prior knowledge as a crime scene investigator in a crime that I was defending someone against. Yeah, and unfortunately, I think he's a judge now. Remember, chat, what I always say: you don't have to be intelligent to be a judge. You just have to be smart enough how to get a degree. Yeah, pass the bar. 2, 3, fill out a piece of paper. And 4, sign up to run for the election. Or, excuse me, pay your $200 filing fee or whatever it costs. That's it. And if you're lucky, hey, you get a 6-figure income and you sit there and don't do a damn thing. We used to have a district judge in Birmingham. He was in the civil side, district judge. He was a cool dude. I liked him. He always into court. He'd say, "Go in peace and roll tide." And he'd sit there with his boots on the bench, napping, because it's all pro se litigant stuff. It's boring as, oh my god, paint drying on the wall, boring. But hey, I liked him. But if somebody else saw it, they go, "Man, this some bitch is lazy." Well, it wasn't hard to get elected. He just got lucky. I don't know what to tell you. You too can do it. You can run for school board. Hell, I don't know. There's all kinds of stuff you can run for. You can run for any office. If you're, yeah, now I'm caught up. Sorry. It's cold here today, y'all. I gotta have a blanket, and I am covered up on it and rolling on it. You can get elected to anything you want. It's not hard. It's really not. But you just gotta get people to like you enough, or get lucky enough to get elected in. Okay, so with that being said, all right, the key purposes. What are the key purposes for a motion in limine? Okay, they're going to be to exclude prejudicial evidence. That's usually going to be from a defendant's point of view. All right, you don't want, and there's rules against that anyway. So it's kind of those would be. I'm not going to say they're rarely used because they are, but th- prejudice is covered in the first few rules of evidence. I mean, you can't unduly prejudice a defendant. The civil side, that yeah, you'll get this. You'll get these more often. So, um, ensure legal compliance. Keep out. Look, there's always everybody says they have evidence. Everybody, I don't care what it is. Like, look at ASAP Rocky trial. Freaking fool brought in shell casings and a damn donut bag. Really? No, shouldn't have happened. Judge should have thrown the shit out. Period. There was no custody. So that's like me saying, I don't know, my house got shot at, and then a month later, oh, I found some shell casings. Um, Here you go, and somehow you trace it back to a gun. I mean, that's absurd. There's no custody and control. It's junk. So you would file something like that, and then to try to keep the compliance, keep them on track to where they don't um, try to sneak it in. Okay. So you keep out evidence that violates the rules of evidence. Prior bad. Oh, another good one is besides hearsay is prior bad acts. Big one. That's probably your biggest one. Prior bad acts. What are they? Okay. Well, let's say my favorite example is serial killers. Or serial um, I don't know, serial burglars, rapists, bad people. God, I hate this software. I like to find something new. This takes too long. Um, Anybody that's got some sort of there has to be a relevancy. Well, I'm gonna go over the rules of evidence in a video soon because nobody ever does that either. They just tell you, and it's like, well, they told me this over here and this over here, and none of it makes any damn sense. It's all over the place. It's not, but it will be if you don't keep it bundled in little sections and then use them as you go. But for prior bad acts, like I would immediately file a motion to eliminate if uh, my client, let's say, he was on trial for 5 or 6 burglaries, and maybe he, God forbid, assaulted a woman in a home to escape. He didn't hurt her real bad, he just hit her and ran out the door to get away. And then they say, well, he was in like 36 fights. He'd been arrested 36 times or 30 times for an assault. Yeah, and it has nothing to do with a burglary. Yes, he assaulted the woman in there, but that doesn't show modus operandi or uh, the type things that a serial killer would have, which is like this. I call it the Hansel and Gretel breadcrumbs. Yeah, okay. It does nothing shows you going from that, having a method of operation, and then using it over and over again. There's nothing there. So those bad acts would be excluded. It would also be improper. Let's say robbed a bank. I don't know. Same dude, same guy. 20 years earlier, 10 years earlier, robbed a bank. Totally irrelevant. Totally irrelevant. And a lot of prosecutors will try because they want to get it in. I mean, they'd be stupid if they didn't. It's going to get probably knocked on an appeal, but they don't care. They're gone by that point. They're on to their next high paying job. They've got 100,000 or 150,000 student loans to pay. These guys, I'm surprised guys like Lewen, he must have gone to one of these California law schools because, like I did in Alabama, that are affordable. Because ain't no way that fool went to 150,000, $200,000 law school and is still doing it. No way. Maybe not. I haven't looked him up. Don't really care to, but I don't think so. Um, so that's what two things you can do with motion in limine. The third is to clarify an admissibility. This is kind of like if you want to get something in and you say, hey, look, man, I want to get X in. And the other side says, no, that's prejudicial. You're like, no, it's not. It's not prejudicial. I can freaking use it. And this may be the type of discussion you have with them in the side room, especially with guys like Lewen. You're a freaking retard. I can get this in. Go back to law school, dude. No, you can't. You can't. I'm gonna file a motion in limine. Okay, I'm gonna file one too. I'm gonna beat you. This is what you would do it for: clarify admissibility, resolve disputes over key evidence before trial, avoiding interruptions. That is what they did not do. A lot of the things could have been helped with just right there. That they were idiots for not doing that. And I don't think it was Takapina. It was Lewin. He was the problem. The guy was a loose cannon. He needs mental help, and I mean that literally. There's something wrong with him. Either that or he's just a complete tool. One of the two or both. I think he's just a jerk, but I could be wrong. I've been wrong in the past, so who knows? I actually had an attorney that was similar to him once, and I made comments about how crazy the guy was. He tried, yeah, he was crazy. He got, yeah, he had to retire, and he was not that old. He younger than me. Uh, I'm 48 now. He's probably in early 40s. I think he has severe schizophrenia, and that was it. And yeah, he was a looney tune. But there's a difference. This guy's just a tool, man. He's just every reaction that Takapina had in court was mild compared to what I would have had. By day 2 or 3, I would have started losing it. In fact, I probably would have begged the judge to fine us for $1,500, $2,000 per speaking objections. And what that means is, we'll get to that speaking objection, but it's more than just a few words. The judge doesn't want to hear your dissertation on it at all. That's not what they want. The judge knows what the hell you're objecting to. Okay, God, remember that. They know if they're smart enough. Most are at least that smart. They know. Some don't. Some go, well, what is your objection, Mister? Oh, Mr. Johnson, what you go ahead and tell me, Judge. It's an objection on relevance. You've heard it. What do we? Oh my God! And you just want to bury your head because you know you're going to be there forever. And it's always over something stupid like a preliminary hearing. Anyway, yeah, when to file? Okay, when to file these? Typically, it's before trial. Well, you can do them during trial. Judges don't like it. That's frowned upon, but you can. Especially like as it says, new issues arise. The effects, it can be granted or denied, obviously. If it's granted, evidence is excluded unless it revisits the ruling, which it will do. You can do that outside the presence of a jury. Or it can be denied. The party can still object when the evidence is introduced at trial, or in vice versa. If it's denied and you can't get it in, uh, and let's say it's excluded, you just immediately admit on um, you just admit on the record. You just admit on the record that there's an issue that you want to visit, and it's about motion to eliminate. It'll get really restrictive in communication. They may do it outside presence of jury, do it on record, and say, I'm objecting for purposes of appeal. I still think you're wrong. I know that we will abide by it, but you're wrong. And most judges are okay, right, noted. And then you're smart if you say, I'm also going to file an objection, continuing objection. And so I don't ever have to do it again. Okay, please let me do that. And courts usually, because it saves them having to sit there and go, objection, blah, blah, blah. They can just go, you know, it's ongoing objection, and it's always going to be there anytime you assert it, even on an appeal. Common uses is prevent interference from interference with reference to prior convictions, as I said, especially if it's more than 10 years old, unless crime of moral turpitude. Let me put that in here. Unless it's a crime of moral turpitude. I can't spell turpitude. What are those? I'll give you a few: murder, rape, lying under oath, treason. There's another one I can't think of offhand. It's just like boo, perjury. Any of those are crimes of moral turpitude. You probably are always going to have those come up. The biggest case, there was a case, I'd love to find it again, but the guy, he was testifying. He wasn't in trouble, but he was testifying. He was a bank robber. It's a federal case. and they were trying to impeach him in his testimony and say, "This guy's a bank robber. Let me see. Look at that. He robbed 32 banks." And he's like, wait. Yeah, I did. I did. I sure did. I robbed him. But the guy's freaking guiltier than hell. He told me in this. I mean, he stuck to his story, and the judge said, "Well, hang on. Yes, he's a bank robber. Yes, he's convicted, but you can't use it because um, bank robbers can tell the truth." When I was in law school, I thought about that. I was like, "Well, that's just ridiculous." But think about it. Um, yeah, yeah, yeah. Just because a murderer commits murder doesn't mean they necessarily can't tell the truth. It, murder's a crime of moral turpitude. So let's skip that. Let's go to um, oh, I don't know, some some white collar type crime that's not a crime of moral turpitude. Maybe hacking or cracking into a system. Um, you might be spending life in prison for doing something like that, and be testifying to it, and they can say, "Look, you can't use." Hey, man, they can't find out about this. He can still tell the truth. Just because he did it, don't mean he's lying. Okay. So, when do we file it? You can file before trial or during. Common uses. We talked about prior convictions, less crime, more turpitude. It's used to exclude or speculative testimony, or irrelevant or speculative testimony. Bar expert testimony that lacks proper foundation. That is a big one that you will do prior to the trial. You better do it, because if that guy's coming in and I don't know, it's as much as Joe Bob, who grows marijuana in his farm and sells the hell out of it and is an expert at growing it and doing everything else with it, he's not going to be an expert witness unless you somehow get him certified, etc., and he's deemed an expert witness. So that would be somebody you would say, "Look, you're not, no, we're not having him testify. I don't give a shit about Joe Bob. He ain't doing it. We're gonna have our own expert. You're gonna have to find you an expert." So that you would file this motion to stop that from occurring, so they don't call them. And this one, you can do it, but this is already a rule and limiting improper character evidence. It's just, we can go into character evidence another time. There are times it can be done. Just remember this: you can, if you're the defendant, yeah, you can do what's called open the door. And if you're on the stand, which you shouldn't be because you're an idiot, um, and you say stuff like, "Man, I'm the nicest guy around," well, you just screwed yourself. Because if you're not, and you've got, like, I don't know, 5 convictions for assault and a DV and I don't know, something else, every one of them's coming in, even though it's a prior bad act. Doesn't matter. You let it in. That's on you, buddy. So keep your mouth shut. Always keep your. Bruce Rivers is right. You got to always go to his channel, like, subscribe. The guy's a legend on it. He has the greatest saying: "No self stitch, no self snitching. Just shut up. Just shut up, and you'll be good." Um, when do I object during a trial? When do one object? During opening statements, you can do it, and that's what we're going to focus on today. Is opening statements. I'm not going to do more than just that. There's that, and I've focused. You can obviously you can object during a trial all the time, but um, these are areas where you really don't. Just go to look. Just get off your ass. Take look. Take ass. Take the ass out of the seat. Seat. All right. Seat's down here. Ass out of seat. Take it out. Go to a courthouse. All you gotta do is go and start asking questions. "Hey, when's your next docket for trial? I want to watch the trial." They'll tell you. They don't care. And go watch it. And you will see it happens all the time. And you've seen it on TV. But I wanted to go over this train wreck, dumpster fire, uh, ASAP Rocky opening and closing. I've never seen anything like it. I mean, like I said, I counted just Lewen's in one day. I think it was over. Well, the judge had him at 17. I had him around 31 because he kept running his mouth. Even after he won, he ran his mouth. take the W, shut up. But he couldn't do it. So on an opening statement, it's frowned on. None of this is good to get. You ask most attorneys, man, it better be a bad freaking issue that they've done, someone's done before they even think about objecting. They may just sit on it and go, oh, God, that son of a bitch. I can't believe he said that. Oh, God. And you'll see them just writing with their pen, just gritting their teeth, because they're taking the notes on it. Because when they do their cross, or they do their, well, not cross, but when they do their opening statement, and like Lewen did on a, like at the end, like a redirect or rebuttal, they call it. Hey, you can bring that. You can go back and cover that. I mean, that's fair game. Um, Judges don't like to let it get out of hand, but you know it happens. But most attorneys, they're just not going to do what you saw in that trial. Attorneys have broad discretion in opening statements, but objections are necessary when opposing counsel does this: argues instead of stating, argues instead of stating expected evidence. Always talk about evidence, 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 or at least what you think will be evidence. That's it. That's all. Nothing else, nothing more. You talk about evidence. You are telling a story that has got to be just the best. It's got to really be just captivating to that audience for them to be. You have to be careful on how you do it. You want them to be in that person's shoes. You want them to understand what your argument's going to be. I mean, you don't just make it. Just come in and go, well, my client's, you know, Joe's innocent, and they have a hard burden to prove, and they have to prove it beyond a reasonable doubt. And we don't think you'll prove it beyond a reasonable doubt. Please find a verdict of guilty. Thank you. I have seen it, like some autistic lawyer getting up there. I have seen it. That's not what you want to do. That's not what you want to do. I'm not the greatest either. Some guys are. I mean, God, just Gary Spence is one. My God, the man. I mean, just fluid storytelling, just fantastic. Trial attorney. Um, so attorneys are objections are necessary when they do argue. When they do arguments instead of stating expected evidence. Okay. An example would be, this case is about corporate greed, and the defendant's actions are indefensible. Objection argumentative. That's all. That was the whole argument with the judge with the two attorneys in the ASAP case. Was, hey, look, I don't want it speaking objection. I don't want to speak objection. It should be 2 words. 2 words. That's what he said. It should be 2 words. There's your 2 words. Objection argumentative. Done. You got to say nothing else. No, Lewen just kept running his mouth. It's like he had to hear the judge say, yes, my son, you are correct. I am so sorry for your loss, and I grieve it. I must fix it for you. Or I guess he thought, and he'd come up to him and pat him on his little butt with a diaper on, maybe shake him, I don't know, and feed him a bottle because he's a pussy. The guy, I've never seen anybody that whiny. Like a bad episode of South Park with Cartman, Oh, God, that guy sucks. Misstatements of fact or the law or facts. Example: the defendant must prove they weren't negligent. No, defendants in criminal cases ain't gonna prove nothing. Objection, misstatement of the law. Burdens on the plaintiff. Really, you don't have to. That's still farther than you need to go. It's just objection, misstatement of law. Is it? Does it? Judge knows. Judge knows, man. He's not a retard. Well, some are. Just gonna warn you. Some are dumb. Remember, I told you they just got to fill out some forms. It's not that hard. It ain't that. I've done it. Got screwed politically, but I've done it. Unfortunately, if you're not a socialist where I'm at, then people come out of the woodwork to get you, even though you're just trying to fix a broke ass system. And make sure people don't go to jail that don't need to. It's not hard, but some people don't want to change. So you can't do that. You can't make you can't, and Lewin did make those arguments, but it was 5 minutes long to make them. I'm like, dude, just objection, statement of the law, burdens on the plaintiff, not or the burdens on the defendant, not us, which is not true. Remember, people tend to forget this. You ain't got to do nothing as a defendant. You can literally come in, get arraigned, and from the moment you're arraigned till the second that jury comes back with a verdict, you can do this. Yes, I mean to be that silent. You don't have to say anything. Everything will be taken in your favor. You don't say anything. It cannot be held against you or used against you in any way. You also can't screw yourself. Of course, you don't provide a defense, but man, maybe it's a case where there is no case and a defense may screw you. You may decide to go when it's the defense's turn. We rest, Your Honor. I mean, that's what they did in the YSL trial. They got him and said, "We rest." That's it. I knew then that they probably were going to win, and they knew it too. All right. So references inadmissible evidence or violations of excuse me motions in limine. These motions in limine. Excuse me. These motions in limine. Sorry, I got to mute this. Sorry. I hope that worked. Forgive me if it didn't. I'm trying to use the mute button. I don't know if it'll work. I hate these stupid headphones. Look like a stupid 12-year-old pimple-nosed lard butt freaking video gaming kid or something, or well, some 40-year-old lard butt pimple nosed video gaming guy or whatever. It never leaves his basement. It definitely hasn't experienced what a woman's like. So that's anyway. So references inadmissible evidence or violations of motions in limine. Motions in limine are going to be outside the presence of the jury. Always mentioning prior convictions that were ruled inadmissible. We went through that. You don't say, "Hey, if this guy's got, well, the guy says, "Oh, I wasn't there," or, um, uh, yeah, I wasn't there. Well, we know you weren't there. You were getting arrested for a DUI and assaulting your ex-wife at the same time. You can't do that. I mean, clearly that might actually give him an alibi, but off the top of my head, that's the craziest thing that you could do. You cannot bring that up. Objection would be just objection to motion limine. That's simple. I mean, you see how simple this is? This is not difficult. This is really, really simple. This isn't hard. Okay. Appeals to emotion or prejudice. This one, it was okay what Lewin objected to because he said that several, but then he turned around and did it. Talking about, what is that? Rakim? Is that his name? Whatever his name is. ASAP. Rocky. His kid, it was a shame his kids would have to come in and see all. No, Takapina didn't object. It was his choice. I sure as hell. Object. That's that's improper. Emotion or prejudice. No, no. Sometimes I don't even get that far. I'm just like object. No, no, because it's that bad. You just can't. If you can't think of anything, just say object. Objection. Objection. It's bad. It's bad. And judge will know. And then the guy will say, "Well, what's the grounds?" It's like, other you want to tell him you're a moron. Dude, you can't try to appeal to emotion on sidebar to emotion or prejudice to get a point across. You can't do that. Like by saying, if you let the defendant get away with this, think how many more people will suffer. God, man, if that's the case, man, you're thinking as a juror, oh, God dang, he's probably right, man. We can't let this guy walk. No, we got to convict him. Not cool. So I can't remember ever using it. But I don't think I would say his objection to proper appeal to emotion. Literally, I'm telling you, it's fine. It's fine to just sit there and go, objection. And the judge may go, okay, what are you objecting to? Don't go into a verbose argument like those two did. Just say he's violating the motion in limine. Thanks, Judge. Or it lacks foundation, or it's outside, it's speculation. It's just that's it. That's all you gotta say. It's not complicated. Tactical considerations. These are kind of important. You should always have a tactical consideration with your practice or with your cases. Ooh, that's a horrible color. If opposing counsel has made a minor mistake, consider addressing it in rebuttal. In rebuttal, guys, in rebuttal. And instead of objecting and highlighting it, do it in freaking rebuttal. That's cool. That's a great place to do it. The judge told him, it's like, hey, man, look, I've made my decision. I've made my ruling. Literally shut the hell up and do it in a rebuttal. But judge, you sound like a freaking 3-year-old kid. But ma, but ma. I mean, it was insane. I mean, all you had to do is look at the other attorneys. Even the guy next to him, the other prosecutor, or times where he was just, I don't know how you couldn't feel that way. Next, let's see. I don't know if we have time to get. Do I have time for this? Let me see. I don't think I think I'd like to wait and do how to object effectively. Let's just run through this real quick. We'll just get through this. This will be fine. All right, how to object effectively. Stand. You don't always have to stand. You just have to freaking say it. That's number one. And do it on the record where they can hear you. Don't have to do it 3 times, just once. Preferably stand. Stand and speak clearly. State your objection firmly but respectfully. Don't do like, what's the grounds? What's the grounds? The grounds? Judge, what did he say? What's the grounds, Judge? Like, what? You're going to jail. Like, I'm still shocked that guy didn't throw him in jail. Don't have long-winded explanations. Just cite the objection. Objection, hearsay. Done. Sit down. Shut up and move on, bruh. If he overrides it, you can say it again. Say, if it's a big one, so you could say, Judge, the second time it happens, say, one more time, objection. I think it's hearsay, and I'm going to ask the court to allow it to continue to be a ongoing objection for the purposes of appeal. That way, anytime it comes up and it's an issue, you can, man, I'm not sorry, my lips are chapped. And there's an issue, the appellate court can see it and it preserves it. Otherwise, you've waived it. Anytime these guys, that is an issue. If you don't get on your crap, if you're not paying attention, if you gamble and say, man, I can save that I can do that on rebuttal. I'll take care of that on rebuttal. Maybe not. Because once you don't do it, gone, waived. Can't use it at appeal. You're done. Anticipate your opposing counsel's response. Be prepared for the judge to ask for clarification. Oh my God, some of them are so done with that. It's like, oh, let me go pull out my damn rule book, Judge. I'll be right back. I mean, it's just, oh my God. That's how you know you've gotten either a newbie or somebody who really and truly is probably book smart, or got into law school based on things that shouldn't have got him there, and really didn't need to be a lawyer. I mean, it's a fact. Most lawyers will tell you that in confidence. And if necessary, cite relevant case law, prior rulings. A lot of these are basic stuff. Like if it's a voir dire issue with venire or something like that, you're going to end up, and it's about race, etc. You're immediately going to know, dude, Judge, this is a Batson issue. This is a Batson challenge. This is a problem now. Sorry, I kept you 10 minutes later. All right, so let me finish this up, and then we'll keep it. Next time, I'm definitely going to keep it at 30. I think I can do it. I got it broke down right. Anticipate opposing counsel's response. Be prepared for the judge to ask for clarification. We did that. Use sidebars when necessary. Huge, huge. Always never feel afraid to say, can we have a sidebar? Does it mind? Not a problem. It's off record. Not a problem. Because you might settle at the sidebar and that's it. Done. Prosecutor may go, man, dude, I didn't realize I did it. I'm sorry. And then judge said, okay, I'll just give either a limiting instruction or I'll just tell the jury right now that, it's a mistake or whatever. Or if it's not bad, but it could be, then they may just address it later if it comes up. But that would, juries usually stay in there for sidebar. I mean, come on, everybody's seen Perry Mason. Sidebar. Be selective. Oh, it's like Sun Tzu. Pick your battles wisely. It's like dealing with kids and telling them what to do and discipline. Pick your battles wisely. Don't just do it over every issue. You should focus on key evidentiary or legal violations, not missteps. Damn, that guy did that. It's freaking bad. So we're going to leave off here. I'm going to type up on here. Pick up here. Next. All right. All right. Cool. And that's what we're going to do. Okay. And we're going to pick up here next. And this time we will go through, or next time we'll go through what it's like to examine a witness for direct and do a cross-examination. Little bit. We're not going to really get into it. And then we're going to talk about, again, this time, closing arguments. Okay. And then we'll try to wrap it up. And like one more 30-minute video. I mean, dude, this is stuff that could go weeks and weeks. It does. It's called law school. A few hours a day, twice a week, sometimes 4 hours in a night, once a week. I mean, it just depends. So thanks for following me. Thanks for staying with me and watching. I'm Chris with Bama Law, and please hit subscribe, like, comment. All the other stuff they say. Hell, I don't know. I'm still new at this. All right, where's my? Can't find my camera. Damn, picture's so small. It's kind of like that's weird. It's kind of like I don't know if you can see me. I can see myself below, but all right. See y'all. And remember, as George Carlin once said, if you want to know why you can't get nothing done in this world, in this type of environment, it's because they're in a club and you're not freaking in it. And it's a true statement. And it's a sad one. So remember, it's in a club. They're in a club and you ain't freaking in it, brother. See y'all later.